Dority.
Right on it. Mr. Dority is also present. All of our jurors are back. I have handed out copies of the jury instructions to all parties. There's copies for the jurors, and I do have the verdict forms up here that we all discussed yesterday. Any other matters or issues that I need to discuss or take care of from the state?
No, Judge, just for as far as jury instructions, do you read the majority of the instructions before closing or after? I know judges split them differently.
I don't have a preference.
I typically prefer the majority of them to be read before, but again, that's obviously, I don't know what the judge's preference is or what you typically do.
I don't have a typical practice. If you want me to do it, I'll do it. If you don't want me to do it, I won't do it. If you want me to do it, tell me where you wanted me to stop at.
Mr. Thompson, do you have
I have no preference either way. I have no preference either way.
I would suggest potentially going up until rules for deliberation, stopping there, and then closing arguments, and then going to the rest of the way from rules for deliberation. It's on page 12 of your instructions. Or 13.
Okay, so you read up through the rules for deliberation, stop there, have you do your closings, and then read those remaining 3 or 4 instructions and send them out.
That would be the state's preference, if everybody else is in agreement.
Any objections?
No objection, Your Honor.
Okay, then I'll do that. Anything else from the state that I need to address?
Nothing further from the state.
Anything from the defense?
Nothing.
All right, we discussed yesterday, each side's agreed to do their closings in 45 minutes or less per side.
Yes, Your Honor.
Yes, Your Honor.
Okay. All right, we do have all the jurors back, so let's go ahead and bring them in. All right, have a seat. All right, ladies and gentlemen, welcome back. I trust that you all complied with the instructions. You didn't do any investigation or any research on your own or have anybody have any contact with you reference this case over the evening, correct? All right. When we spoke yesterday, both the state and the defense had rested their cases. The court released you all early so that we could finish the jury instructions and the verdict forms. We have completed that. You do have a copy of them. You're free to take those back into the jury room with you. What we're going to do is I'm going to split up the way that I read the jury instructions a little bit. I'm going to read the majority of the jury instructions through about the top of page 13 to you now. I am required to read the jury instructions to you. I give you a copy so that you can take them into the jury room with you, but I have to read them out loud to you. The reason I'm reading the first about 12 pages to you is so that you hear from me what the law is that applies to the case before our lawyers argue to you what the law is and what the facts are that may apply to that law. So you'll have heard it from me first so you know what the law is as they make their arguments. Then they will do their closing arguments, and then I will pick up on page 13 with the last few instructions before I send you out and go over the verdict form with you to let you deliberate, okay? All right, so with that said, we'll go ahead and start with the reading a portion of the jury instructions before they do their closings. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Lawrence Alexander Dority, the defendant in this case, has been accused of the crime of second-degree murder with a firearm. In this case, Lawrence Alexander Dority is accused of second-degree murder with a firearm Murder in the second degree includes the lesser crime of manslaughter, which is also unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Adrian D'Angelo Payne was killed by Lawrence Alexander Dority, you will then consider the circumstances surrounding the killing and deciding if the killing was second-degree murder, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and adequate provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Lawrence Alexander Dority may be found guilty of second-degree murder or any lesser included crime. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Adrian D'Angelo Payne is dead. 2, the death was caused by the criminal act of Lawrence Alexander Dority. 3, there was an unlawful killing of Adrian D'Angelo Payne by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another person and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Lawrence Alexander Dority did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life, because he acted in the heat of passion based upon adequate provocation. A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Lawrence Alexander Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Adrian D'Angelo Payne. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of second-degree murder with a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused the death of Adrian D'Angelo Payne, you should find the defendant guilty of second-degree murder with discharge of a firearm causing death. A firearm is legally defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. To prove the crime of manslaughter, a lesser included offense of count 1, the state must prove the following two elements beyond a reasonable doubt. 1, Adrian D'Angelo Payne is dead. 2, Lawrence Alexander Dority intentionally committed an act or acts that caused the death of Adrian D'Angelo Payne. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Lawrence Alexander Dority committed manslaughter and you also find beyond a reasonable doubt during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm, again, is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. It is a defense to the crimes of second-degree murder and manslaughter if the actions of Lawrence Alexander Dority constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Lawrence Alexander Dority does not have the burden of proving that he was justified in using or threatening to use deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force is as follows. Lawrence Alexander Dority was justified in using or threatening to use deadly force if he reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to himself, or the imminent commission of a forcible felony, aggravated assault, against himself. The definition of aggravated assault is as follows. An aggravated assault is an assault with a deadly weapon without intent to kill. An assault is an intentional, unlawful threat by word or act to do violence to the person of another, coupled with an apparent ability to do so, and doing some act which creates a well-founded fear in such other person that such violence is imminent. Lawrence Alexander Dority had no duty to retreat before using or threatening to use deadly force. In deciding whether Lawrence Alexander Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. However, the use or threatened use of deadly force is not justified if you find that Lawrence Alexander Dority used force or threat of force to initially provoke the use or threat of use of force against himself, unless 1. The force or threat of force asserted towards the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using or threatening to use deadly force on the victim, or 2, in good faith, Lawrence Alexander Dority withdrew from physical contact with Adrian D'Angelo Payne and clearly indicated to Adrian D'Angelo Payne that he wanted to withdraw and stop the use or threatened use of deadly force, but Adrian D'Angelo Payne continued or resumed the use or threatened use of force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Lawrence Alexander Dority and Adrian D'Angelo Payne. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflicting the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? And 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, 1, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, I'm going to stop reading the jury instructions. At that point, I will pick up with the remainder of the jury instructions after the attorney's closings. As I indicated, both the state and the defense have now rested. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence, nor your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Does the state wish to give their closing at this time?
Yes, Your Honor.
You may.
Thank you, Your Honor. May I please report? Carol Walker pled with the defendant not to take his gun out. She pled with him, don't take your gun out. Over again, don't take your gun out, Lawrence. We were asked to come here. She pleaded with him not to shoot Adrian Payne that night. But he didn't listen. Instead, he proceeded to take his gun out, take deadly aim, and shoot and kill Adrian Payne. It wasn't justified. It wasn't in response to a reasonable threat. It was just because he was intoxicated and he was mad. Not in the heat of passion that would be justified by law, but just because that's how he felt like, what he felt like doing that night. Not justified. Now, this was a relatively short trial. You heard from 6 state witnesses, as well as the defendant, including Tara Walker. And obviously you heard from the witnesses yesterday, so you probably have fresh memories of what was said, but I want to go through and touch on what I think are important points for you to remember when you go back for your deliberations. First, you heard from Corporal Garrett Morris. He was one of the first responding officers on scene. Now, he came to the scene and he found the victim suffering from a gunshot, and he was still in his vehicle. Now, you heard from the testimony, he was a large individual. He was 6'8", and they had difficulty getting him out of the vehicle. They were able to ultimately get him out. He tried to render aid on the ground at CPR with another officer. Unfortunately, he was unsuccessful. Now, you heard as part of protocol for when responding to a scene like this, a shooting, that he checked for weapons on the victim's person. And you can actually see on his body camera video that you saw that he did check both a pouch that the victim had on and as well as his pockets. No weapons. You also heard from CSI Hannah Miner, who testified yesterday morning as well. She was the lead CSI in the case, and she was in charge of documenting the entire scene, including the inside of the victim's vehicle. And you saw her documentation of that scene produced no firearm. There was no firearm in the vehicle. There was a kitchen knife in the passenger floorboard that you heard from Tara Walker was put there by her after a dinner that they had picked up. You also got to see from CSI Miner's photographs sort of a layout of the scene. You got to see that the victim's vehicle wasn't parked right in front of the defendant's house, but down the street a ways, at least a couple of residents down. You saw that the vehicle wasn't on his property. It wasn't on anything adjoining his property. You got to see the distances between the defendant's door and where the victim had parked. You got to see her photographs detailing her search of the defendant's residence where the firearm was found. And you saw the firearm itself, which is in evidence. You heard briefly from Marco Quintanar, who was a neighbor in this incident. He didn't see anything, but he heard gunshots, which caused him to look at his surveillance camera, and he was able to find video that captured audio of this shooting. And of course, you heard from Tara Walker, the victim in this case, his girlfriend, the mother of his child. She told you that she responded to the area of the defendant's house after receiving a call from her best friend, Tatiana Mesa. That she then spoke with her boyfriend, Adrian, who said he was also en route there as backup to her. Now, you heard that she got there just after Adrian had arrived and saw the defendant sort of walking away after apparently having words with Adrian going back into the house. You heard she had a brief conversation with him. He was going to move his car so she could fit to park on the street there. And then you heard that's when things took a turn. The defendant came back outside the house. He didn't stay in the house. He didn't lock the door. He didn't call 911. None of that. Instead, he arms himself with a firearm, taking the time to do that. He comes back out, and when Tara Walker sees him, she notices that he seems to have a gun. And she says, and you can hear on the audio, "Don't take your gun out. Lawrence, don't take your gun out. We were called here." But then she told you he didn't listen. He does take the gun out. You can hear the escalation in her voice. While you can't see the incident, you can hear it play by play from her voice on the video and the shots themselves. And you hear just after that, after he's been warned, after he's been told why they're there, you hear the shot ring out. And then you hear screams. Because the defendant had killed Adrian Payne for no justifiable reason. And you hear that in that surveillance. You then saw on the video, and you heard from her, that she ran down to a neighbor's house. She tried to get help. And then she continued running, trying to get help from other neighbors. And then ultimately, when law enforcement came back, she was back to the car to try to render aid to her boyfriend, who unfortunately succumbed to the injuries. Now, you also heard from the medical examiner in this case, Dr. Marie Hansen. She told you about her extensive experience as a medical examiner since 1990. She told you about the autopsy she performed in this case. And she told you about the positioning of the victim's body when he was shot, that his arm would have had to have been up like this and to go through his torso for the shot. She said that was consistent with, and obviously she wasn't there, so she can't say specifically, but it was consistent with someone having their arm either perched on a door frame or on a steering wheel, just as Tara Walker said. She also said that based on the position, it's likely that the thumb was down. That's not a position that someone would be pointing a firearm, which we know that the victim in this case never had. But instead, a position of somebody that's by his car or in his car, nowhere near this defendant's residence, not on his property when he was shot. You heard from the medical examiner that the cause of death was that gunshot as it went through and pierced the aorta, and you heard that the manner of death was homicide. You also heard from firearms expert with FDLE, Kristen Killinger, just that confirmed that the gun that was found in this defendant's home was in fact the gun he used to kill the victim in this case, and that the bullet that was removed from the victim in his autopsy was in fact fired from that defendant's gun. Now, you also heard from the defendant in this case, and part of your job, as is your job with all the witnesses that testified, is to weigh their credibility. Now, the judge just instructed you with an instruction on weighing the evidence, and it goes through the factors that you look at when weighing the credibility of a witness that testifies. And that's your job as a juror, to go through that with each witness and determine what you find credible and what you find to be not credible. Now, I want to talk about some of those that are of particular importance, I believe, to this defendant's testimony. Did the witness seem to have an accurate memory? Well, you heard his testimony as he said certain things with his counsel, but then when I questioned him about it, I said, well, it had been a long day, I'm not sure, I might not have said it. Did you find that to be credible? Was the witness honest and straightforward in answering questions? Well, he was barely audible when answering questions from his attorney, but he was at least cooperative. But then when I asked him questions, you saw his response, talking around the question, not giving me direct answers, having to be impeached multiple times with his previous statements. Did the witness have some interest in how the case would be decided? Well, no one that you heard from yesterday has more of an interest in how this case is decided than the defendant, obviously. Did you find his demeanor on the stand to be credible? Or did you see the tears, if there were any, to be crocodile tears that he was trying to force to gain sympathy from you? What do you believe? Did his testimony agree with the other evidence in the case? Well, no, it was in conflict with the testimony of Terrell Walker, and that testimony of Terrell Walker is corroborated by the video and the audio from the surveillance video. And did the witness at some point make statements inconsistent? Well, several times. I mean, just out of the door in his direct testimony, he said he had never been Mirandized, but then obviously he was impeached on the transcript of him being read Miranda. He said that he, didn't initially, so they didn't try to talk to the victim when he came back out. He didn't communicate with him. He shot him. That's what he said just after this murder. But then after watching all the evidence, he gets on the stand and says he came out there and was trying to, talk, please leave, please leave. First of all, I question that is the demeanor that he came out and was asking Mr. Payne to leave. But also, Adrian Payne was not on his property. He was on a street that was not even touching his property, and he didn't have any less of a right to be there than the defendant. He also said definitively, as you heard in his direct testimony, he definitely saw a gun, but he never said that in his initial statement. What he said is he thought he saw the outline of a gun. He's not sure, to be honest, he's not sure. That's what he originally said, but after hearing the evidence and realizing what needs to be said in order to convince you that he was somehow justified in his actions, that's what he said on the stand. But it's not consistent with what he said before, and it's not consistent with the facts and evidence in this case. Now, from the evidence in this case, it is clear that this defendant is guilty of second-degree murder with a firearm. The judge just went over with you the elements of that offense as well as the lesser-included offense of manslaughter. But I want to take a minute and go through those with you as well and go through the facts as the state believes they apply. So the judge will instruct you and you have in your packet that you are to convict of the highest crime proven beyond a reasonable doubt. And that's second-degree murder. Now, here there's a lesser-included offense of manslaughter, but I want to be clear, and I'm going to talk about manslaughter, but I want to be clear. In jury selection and in these instructions, you're going to be told to not let sympathy or concerns about sentencing impact your deliberations in this case. So if you believe that we've proven this case beyond a reasonable doubt regarding second-degree murder, it is not appropriate to say, well, maybe he was scared even if it wasn't justified, or maybe whatever the situation is, he's, not that old, I don't want him to, go to prison for a long time, or whatever the case may be. That is not appropriate. That is not the consideration for the jury. You are to convict of the highest offense proven beyond a reasonable doubt, and that's second-degree murder. But I'm going to talk about manslaughter because we have proven the elements of manslaughter as well, as it is a lesser-included offense. So to prove the crime of manslaughter, the state must prove it's just two elements. And there's a couple of big differences between manslaughter and second-degree murder. First, there's just two elements. There's three elements to second-degree murder. Manslaughter does not require any type of mental state. So second-degree murder requires that he acted with what the law calls a depraved mind. I'm going to talk to you a little bit more about that in a minute. But manslaughter does not require that. It just requires that A, Adrian Payne is dead, which is stipulated to. Obviously, we've established that he is deceased, and that the second element is Lawrence Dority intentionally committed an act or acts that caused the death of Adrian Payne. Now, obviously, in this case, that act is taking his gun and intentionally shooting him. That's it for manslaughter. Now, you're going to see that for second-degree murder, there is an instruction regarding heat of passion. That doesn't apply to manslaughter. So the two things that you can consider for manslaughter for elements are that Adrian Payne is dead and that the defendant committed an intentional act that caused the death of Adrian Payne. We've proven manslaughter. We've met those elements. But you should not convict him of manslaughter because that's not the highest crime proven. So I want to talk about second-degree murder. I'm going to put it up here. I know you have it in your packets, but I want to talk about it in a little bit more detail. And if you can't read it exactly on the screen, again, I say you have it in your packets. It is on page 3 of your packets. But so there's the same. The first element is the same, that Adrian Payne is dead, and that the death was caused by the criminal act of Lawrence Dority. That criminal act is taking his firearm and shooting him while he's sitting in or by his car. The third element is the difference, that there was an unlawful killing of Adrian Payne by an act eminently dangerous to another, demonstrating a depraved mind without regard for human life. So, ladies and gentlemen, I pose to you that obviously taking a firearm and shooting another human being demonstrates a depraved mind, and eminently dangerous to another and depraved mind is defined for you. It says a person of ordinary judgment would reasonably certain to kill or do serious bodily injury. A normal person knows if you take a gun, you point it out, and you pull the trigger, it's going to cause bodily injury, or it's going to kill him. It's done from ill will, hatred, spite, or evil intent. And I want to point out that these are ors. So you can find that it was done from ill will. He was upset that he was outside his house. Hatred, maybe he was that mad that he was outside his house. Spite or evil intent. You can find any of those. You don't have to find all of them, but if any of those satisfy the depraved mind requirement. And he certainly had that, and his actions demonstrate that he had that. And then finally, is of such a nature that the act itself indicates an indifference to human life. And again, some of these things overlap with each other. Obviously, again, taking a firearm, pointing it, and shooting at another human being shows that you're indifferent to that person's life. Now, with second-degree murder, we do not have to prove an intent to cause death. So that's not something that you consider. Maybe he just wanted to injure him or whatever the case may be, if that's what you believe. I think the facts show that he took deadly aim and intended exactly what happened, but you don't have to find that. You don't have to find an intent to cause death, just that he had an intent to shoot him. So then there's the portion that talks about the heat of passion. And there are some subsections here, A through E. But each of them talks about an ordinary, reasonable person. So it's not just, well, I was scared, so I did it. That's not sufficient for heat of passion under the law. It's not sufficient to say, I was upset, and so I did this thing, and I'm excused from it being second-degree murder. No. There must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. Again, that language, ordinary, reasonable person. And then, and again, I want to point out too, all of these are ands. So you have to find all of them. for these actions to be reasonable. A reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. So the question is not just, was this defendant in a blind, unreasoning fury? He was certainly not acting reasonably, but would a reasonable person have acted that way? No. There was not a reasonable amount of time for a reasonable person to cool off. This defendant took time. He went in his house. There was no threat at that point. He wasn't pursued. He armed himself. He came back out. There was no further threat. He's being begged and pleaded with to not do what he did, but he still did it. So he certainly could have cooled off when he went in the house. And then another and also has to be met. A reasonable person would not have cooled off. So say he was so upset by whatever interaction that they had out by the victim's vehicle before he went in the house. A reasonable person, when they go in their house, can shut the door, can lock the door, can do whatever, can cool off, before coming out and doing what he did. And then finally, he was so provoked that he did not cool off before he committed the act that caused the death. So it's not just a matter of, I was scared, this was a scary situation, and therefore I did this and I should be excused of second-degree murder. No, you have to look at it based on a reasonable person. And the defendant in this case and his actions were anything but. So the defendant in this case took the stand and claimed that he was acting in self-defense. He was justified in his use of deadly force. But that is not the case when you look at the facts. The defendant's actions were not reasonable. The judge has given you a lengthy definition of justifiable deadly force. That's on page 8 of your packet. And for something to be justified, it must be both an objective justification and subjective. And I want to go through a specific paragraph that is in your instructions that explains that and how that works and what you're to consider. The second from the bottom on this page, I don't know on your packet, but it starts with in deciding. So the judge has instructed you, and you're going to have this in your packet, in deciding whether Lawrence Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force threat was used. So that's important because he didn't use the force, when they first had words and he decided to go in the house. This is after he had gone back in the house, had time to cool off, arm himself, and come back out. And other people, were present at this point, including Tara Walker. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. So first of all, this wasn't threatened use of deadly force. I guess maybe it was in the moments just before he pulled the trigger, but this was deadly force. He did pull the trigger in this circumstance. And he himself must have actually believed in that moment that it was necessary to do what he did. Not that he wanted to, but that it was necessary. And beyond that, even if beyond just necessary in his mind, moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed that the use or threatened use of deadly force was necessary. A reasonably cautious and prudent person. This defendant's actions were not the actions of a reasonably cautious and prudent person. That's for you to decide when you look at the facts of the case and you look at the evidence, but the evidence has shown that what he did was not the actions of a reasonably cautious and prudent person. The defendant in this case was not standing his ground. He was the aggressor. He was the person that initially approached a car parked on the street. This person wasn't knocking, on his door, wasn't standing on his lawn. He was sitting in his car with the window rolled up. He was the one that made even an initial contact. This was not an act of defense, and it certainly wasn't an act of reasonable self-defense. He took a life not to protect his own or to protect his family. He took it because he wanted to, because he was upset. His actions show a depraved mind, and he's guilty of second-degree murder. We ask that you convict.
All right, defense,
Your Honor, maybe pro smoke briefly.
come on up.
I don't have an objection.
Okay. All right, counsel, for defense, you may proceed.